This is real estate attorney Earl White, and this is a video about some of the differences between a party buying and selling a cooperative unit versus buying and selling other forms of real estate, particularly in a competitive market where there are a lot of buyers hunting for deals. A co-op may be a good alternative where they can not have to overpay, not have to waive everything, not have to waive appraisal, and still get a property that meets their needs. That said, co-ops can be very different, and it's good to prepare all our clients ahead of time about how that process is going to go so there's no shocks, difficulties as it's moving forward. Now, this video is going to cover, what is a co-op from a legal perspective? What are the differences in co-op sales versus standard other real estate transactions, and strategies and tips as to how you can approach those differences. So first, what is a cooperative? And I'm going to read straight from Preston versus Saylor from the Appellate Division in 1988. Legal title to the real and personal property of a cooperative complex or project is vested in a cooperative corporation, and individuals purchase shares of stock enabling them to occupy a dwelling under a proprietary lease. So there's two main items here from this definition. One is the shares of the corporation. When you're moving in and buying in a cooperative, you don't own real estate, you own shares in the cooperative corporation. In addition, you have the proprietary lease. Lets you stay, occupy the unit that your shares are assigned to. So at a high level, that's the legal definition of what a cooperative is in New Jersey. When the cooperative association is being formed, there are several documents they have to file with the state. Now, I'm going to read right from the Cooperative Act of New Jersey. So they have to create bylaws and file those bylaws, which are essentially the rules and regulations for the cooperative. Not so much the day-to-day rules and regulations like pets, policies, not so much that, but more dispute resolution, how the property is going to be set up, high-level issues that you're going to come up, not every day, but when disputes arise, when they're transferring shares, those type of things have to be laid out in the bylaws. In addition to that, they have to file any restrictions on the use, occupancy, transfer, leasing, or other disposition of any unit, that the restriction or limitation is otherwise permitted by law, and limitations upon the use of the common elements. So when they're forming the corporation, they have to register how the properties can be used, any limitations on that use, and how they can be transferred. So that's some legal background on co-ops. So how is the co-op process different? Now, in New Jersey, standard attorney review process, right, is realtors prepare a draft contract, submit it to the buyers and sellers, they sign the contract, and then they kick it to the attorneys, the signed contract to the attorneys for standard 3-day attorney review. Now, standard realtor contract is only applicable to 1 to 4 units and single-family vacant lots. So it doesn't apply to co-ops. So the initial contract is either just, not binding at all, or it serves more as a letter of intent for the main terms of the contract, So a lot of times I'll see agents just do a one-pager. What's the price? What's the deposit? What's the mortgage? And what's the closing date? And then at that point, you send it over to the attorneys to draft. Now, it's drafted from scratch. So I think it's worth, when you're sending the cooperative deal to the attorney, just make sure they don't forget to add in standard terms such as appraisal contingencies, inspection periods, because I can tell you virtually every draft cooperative contract is not going to have the inspection contingency. And I've seen some transactions where the attorney drops the ball and it never makes it into the contract. I get an inspection report and I'm like, hey, there's no inspection contingency in this contract. Why send me inspection requests? So we want to make sure the attorneys are on the ball on that. Now, in terms of drafting the contract, some co-ops, not all, have requirements about what has to go in the contract. So I always recommend, if it's not an established co-op or a smaller one that you haven't worked with before, it makes sense to find out ahead of time. I did one recently where I called the co-op attorney and asked him if there were any rules or regulations for the offer. He's like, no. As we get further down the road, it turns out that there's a minimum of a 10% down payment on the offer. My client was at 5%. We did get an exception made by contacting them and explaining we reached out a month ago. We were told there was no issues with our offer. We drafted it and we've come down here, and can they make an exception for us? And they did make an exception for my client after we pushed them, but still the deal could have fallen apart. If given that we didn't have the information, but if you didn't even ask, there would have been no way to know that until later in the process. The other thing to really be careful with is the time frame for getting the mortgages. So you'll have a mortgage contingency in the co-op deals, just like you would in other deals, but the mortgages take so much longer to get. I can't remember the last time. Like standard realtor contract, mortgage contingency, default 30 days. If it's an FHA, maybe 45. I can't remember the last time that I had a mortgage commitment in a co-op in 30 days. Like it just never happened. So tell your clients up front, it's 30 days. That's what's the contractual deadline. And particularly on the seller side, you're not going to extend it. But what I tell every client I have, when I get a contract for a co-op and everyone's looking for 30 days for the mortgage commitment, I'm like, look, let's leave it there. We'll do our best to get the mortgage commitment in 30 days, but just be ready. It's going to probably take 45 or even 60 just because of the nature of the co-op. So that way, when the dates start passing, same thing with the closing dates. I get co-op contract, closing date might be 30 days, 45 days, whatever it was set up. And I'll tell my client, like, look, it's somewhat not realistic. Like, we can go forward, particularly if you're on the seller side, you're not short on the dates. I mean, you want to keep a little fire into the fire, but you prepare your seller client, like, look, we're probably not going to meet this deadline. If it happens, don't get upset if it happens. And, we'll keep moving the transaction forward, but just prepare them mentally that things are going to take longer than if it had been a standard sale. Now, also another big difference in the co-ops versus other sales is the board approval. Normally in New Jersey, even condo sales, other states are different, but normally in New Jersey, there's no approval process, even for condos, like a little bit, but it's really not substantial compared to what you might see in Florida or other states. With the co-ops, it's a little different. Once you get the mortgage commitment, that's when they're going to schedule an interview between the buyer and the co-op. And I've rarely seen a deal fall apart at the interview. It's pretty rare, but there could be issues that come up. And like I've seen issues come up regarding like debt to income ratio, because you're taking on a lot of fees in the co-op. So the co-op may then sort of look at the income even beyond the mortgage commitment. Like the mortgage is good, but the co-op then has their own rules about what the debt to income has to be. And so that can be something to deal with, but that's just one example where you might come up with something at this interview. But again, the interview also delays the process, right? I've seen they won't do it until you have a mortgage commitment. So mortgage commitment takes longer. Then you get the mortgage commitment, then you'll wait 2 more weeks to get the interview. Then you got to wait another week to get the approval after the interview. And now we're talking about, or almost 3, it can be, let's see, we can almost 2 months into the transaction and we don't have it clear to close on the mortgage or a closing date yet. So that's be ready for the mortgage and the interview process taking longer. Now, the closings at the co-op are obviously, substantially different. Traditional closing for standard real estate transaction, once we get this clear to close for the mortgage, we pick a closing date. Usually the seller, at this point, the seller will mail over their closing documents. Buyers will come to the buyer's attorney's office in most cases. Settlement agent will come to the title company. We'll sign a bunch of mortgage documents. And then, either scan them back to the lender, or maybe that completes the closing and the deal gets funded to the seller. And then we're done. Keys transfer, and then we're done. Co-ops is not the same. Obviously, there's no deed, as we talked about before. There's a share certificate, we talked about before, and proprietary lease that has to get transferred. But the difficulty, or one of the things to really, really be aware of, is that when the seller originally bought it, they got a share certificate, proprietary lease, like we've been saying. And they may have copies of it, but they need the originals. The original share certificate and the original proprietary lease. And normally those are held by the lender and the lender's attorney. And so whoever gave the seller the mortgage to get that property, it is difficult. I mean, it's an understatement how difficult it is to get the lender to give you those documents because you need to give the original. Now, in some cases, it's almost proved impossible to get the documents. I've had cases where the lenders have refused to even give them over until the deal closed. So what you can do in those situations, if you run into it, is you get a certificate of loss, a share certificate, or a certificate of loss proprietary lease. Now, they're not necessarily lost. In some cases, they are. In some cases, the lender can't find them. The client can't find them. So then you can do that if you don't have the originals. In other cases, if the lender's not going to use it, then you can do some kind of documents like lost documents. And then normally the buyer will indemnify the seller in like a short indemnity agreement that should there be an issue because we didn't have the originals, then the buyer indemnifies the seller, which is only fair because the buyer can't get the closing documents to the seller, can't get the closing documents to the buyer. So that's the other thing to be aware of. So that's the breakdown of what a co-op is, some of the differences in the process, and how you can prepare your client and get everyone on the same page to make it go as smooth as possible for a process that is going to be more difficult than other processes. So hopefully this video is helpful for you and helpful for passing on information to your clients if that's the case. And please give it a like, please give it a share if you found it useful. Thank you.